So today's session, the idea for me in doing these sessions is always to keep it interactive. I'd like for you guys to participate as much as possible. Instead of telling you something, I'll likely try and ask a question. And if anyone answers, that would be great. It's okay if you get it wrong. That's how we all learn. That's how I learned it. That's how I keep learning. And maybe you'll ask a question I don't know the answer to, and then I'll have to look it up. And that's some way in which I'll learn too. So at any point, if you want to ask a question, you can raise your hand. You can put it on the chat box. I'm keeping the chat box open. I will stop where I am and address the question directly because I think that keeps the engagement more real and keeps things more interesting. A little bit about the area of law we're talking about, which is the fabrication of evidence. It's not something that is the creme de la creme of criminal law or civil law. In fact, everyone, sadly, in India, to some extent, fabricates evidence all the time. And I'll get into the practicalities of it once we go deeper into the subject. But just because it's not the first thing you learn in law school or the first thing you practice when you get into litigation, doesn't mean it's not important. In fact, it's arguably the most crucial part because all trials at some level are focused on capturing instances of fabrication of evidence. Whether you pursue filing a case for fabrication of evidence or not, you will always in cross-examination try to catch a lie. You will always in examination of documents try to catch that document which is being misread or which has been in extreme cases forged and fabricated. So without further ado, let's move straight into the subject. Now you have to start always with when you use the phrase fabrication of evidence, at what is evidence? And the definition of evidence is provided in the Indian Evidence Act. It says all evidence means and includes all statements which the court permits or requires to be made before it by witnesses and all documents, including electronic documents. So when we talk about the fabrication of evidence, we're not just talking about forged documents, we're also talking about statements which are untrue. People who are essentially lying on oath before the court. You can't restrict your idea of fabrication of evidence only to, when you hear the word fabrication, you think of documentation. But since the word evidence also includes oral statements, we will also have to consider instances where people lie in court. And as you will find out when you get into litigation, or if you all are litigating already, you already know people lie in court all the time. It's an unfortunate reality, whether it's a criminal case or a civil case. Your clients will tell you something, the truth will be completely different, but they'll have no qualms about saying what they want the truth to be in court. And of course, forgery of documents is a little more serious, but I'll get into the details of that later. Now, what are the relevant provisions for fabrication of evidence in terms of penalizing it or criminalizing it? If you go to the Indian Penal Code, there's a specific chapter which deals with this particular angle, which is chapter 11 of the Indian Penal Code. Now, I hope all of y'all can have a copy of the Indian Penal Code in front of you, either on your laptops or on a hard copy, whichever works for you. I'm just going to quickly run through the sections because all of them are fairly straightforward and can be read in your own time. Section 191 talks about giving false evidence, which is where you orally make a statement which is false. And section 192 talks about forgery of documents to some extent, where there are false entry in books, or making of documents which are false and used in a trial, in a judicial proceeding, committing the offense of fabricating false evidence. The punishment for both of them is given under section 193. And if you read a little further, section 194 makes it a graver offense to give false evidence in a criminal trial, which is concerned with a capital offense, that is with the death penalty. And thereafter, there are different degrees of the way in which giving false evidence has been penalized. For example, it is the most serious offense to give false evidence, obviously, in a trial which has the death penalty. It is more serious to do so when it's a trial which may involve life imprisonment. You will also see section 195A, which is threatening any person to give false evidence, which is very common, which is where, you will tell someone, agree with me or I'll file a case against you and claim XYZ. You have to criminalize this separately because although the person hasn't committed the offense of giving false evidence, he's threatening with it to get a result in his favor. It's similar to extortion in that sense. Moving on to other provisions, 196, 197, fairly straightforward. You can read through these sections in your own time. But the relevant point here is all of them are connected with taking a document which you know to be forged or forging it for the purpose of giving it in as false evidence in a trial, whether civil or criminal, and making a statement in court that you know to be untrue and therefore trying to get a decision from a judicial forum in your favor despite knowing that the statement is untrue. This is a fairly intuitive fact. The question becomes the issue becomes a little more complicated in how do we pursue a complaint for false evidence. Does anyone know the difference between an average offense and an offense for false evidence? Whether there is a difference in the procedure in which you have to file a complaint in respect? Anyone with any guesses? Anyone who's aware of the relevant provisions? Anyone who thinks there should be a difference? I'll give you guys 5 seconds and then I'm going to speak. I remember when I used to take these classes physically, I used to cold call people and force them to answer, but that's not really viable in an online. So the thing about prosecuting false evidence is the law mandates that you can't simply go and file an FIR for it. You have to make a complaint to the court in which the false evidence has been given, and then that court will conduct an inquiry, and thereafter that court will decide whether to pursue a case for false evidence or not. I'll get into which provisions govern this in a moment. But the first question that really comes to mind is why. Today, if I hit you, you can file an FIR. Today, if I stab you, you can file an FIR. If a husband treats his wife cruelly, she can file an FIR. But something as serious as giving false evidence requires you to first approach a court, which is hearing the case, tell them, look, he's giving false evidence. That court conducts an inquiry, and then that court decides whether to pursue it or not. Why have they created this complicated procedure for something that is as serious an offense as the ones I mentioned earlier? Can anyone take any guesses? Try to rationalize it. It's actually a very logical thing. And the law is, the law is not always perfectly logical, but there is some basis for the law. So can someone take a stab at why this is the case? Why if in a trial that's taking place, I see someone is giving false evidence, I can't go and file an FIR with the police. I have to tell the court, look, he's giving false evidence. The court will conduct an inquiry and thereafter pursue the matter if it decides. It's a little complicated. The answer is this. In any trial, two sides are always saying the other is lying. There will always come a point where one person thinks the other is lying and the other thinks the initial person is lying. And they will always be saying opposite things to each other. So if you allow people to simply file FIRs for false evidence, every time a witness gives his testimony, the other side will naturally want to file an FIR as a pressure tactic. The other side will naturally say, no, he's lying, and go and keep filing police complaints and criminal complaints. Because there is an inherent difference in opinion and, of course, a difference in fact once the court comes to a decision that has led to the trial taking place in civil trials, as well as in criminal trials, where the accused will naturally think he is innocent and will therefore naturally think all the witnesses against him are lying. And therefore, every time a witness comes and testifies, the accused will have to file an FIR against that witness. Or every time, because he has to establish his bona fide. So the law cannot allow for such a mechanism where people will constantly be filing complaints against each other just to pressure them in proceedings. That's reason number one. Reason number two is a little more nuanced. The court is already seized with the matter where the false evidence has been given, whether it's been given in a documents form or orally in some form. In such a situation, the law recognizes that that court is best placed to make an assessment on whether this is an instance of giving false evidence or whether this is an instance of a difference of opinion. And in such a situation, rather than going to the police and making them conduct a fresh inquiry, the court should, since it is already seized with the matter, decide whether a complaint should be pursued or not. Now, I'll elaborate on why this is important in the form of an example. Let's assume there's a criminal trial taking place. There is an accused individual in that trial. There's a witness who says she saw the accused at the scene of the crime. The accused thinks he was not at the scene of the crime. And that the reason the witness has got it wrong is because it was dark and she mistook someone else for the accused. This is not a situation where the witness has deliberately given false evidence. This is a situation where the witness is stating what she or he thinks to be the truth. And the defense taken by the accused will be, it is dark, you could not see. Does such a witness deserve an FIR against her or him? Will anyone be willing to give evidence in courts if they have to constantly be afraid that the other side will file FIRs? Everyone will back out of anyway. People are unwilling to come to courts and give evidence, and it takes up their time. It's pressurizing. It's inconvenient. If they are also afraid of legal consequences, they simply won't do it. And therefore, the law says that a judicial mind should be applied on whether a witness giving evidence should have proceedings against it, even if it's got something wrong. So let's get into the legal provisions that govern this. So like I said, you can't simply file an FIR for the fabrication of evidence. You have to go and file it So which section stops you from filing the FIR? Does anyone know? It's in the CRPC, the Criminal Code of Criminal Procedure. Mansi, section 154 of the CRPC is not the right answer, but thank you for trying. I think you were referring to section 154 of the CRPC being concerned with FIRs, which says you can give information in relation to cognizable offenses and therefore an FIR will be registered. But the section I was asking about, which is the right section for a normal any other crime, which is cognizable in nature, section 154 CRPC. But the question I'm asking is, which section of the CRPC stops you from filing an FIR in the case of fabrication of evidence? It's not very straightforward and it's perfect. It's not 155 either, but thank you for trying. The right answer is section 195 of the CRPC. If you go to section 195 of the CRPC, section 195(1) says no court shall take cognizance. And if you go to part B of that, it says any offense punishable under any of the following sections of the Indian Penal Code, namely section 193 to 196, 199, 200, 205 to 211, and 228, when such offense is alleged to have been committed in or in relation to any proceeding in any court. All right. What this means is a court will not take cognizance of an offense straight away under these sections. And you have to read the last part of that section, except on the complaint in writing of that court or by such officer of the court as that court may authorize in writing in this behalf. So this means that the only forum and the only person who can file a complaint for fabrication of evidence is the court or an officer authorized by the court where the offense took place. This is a bar under the usual process of criminal law under section 154, where any individual can go and file an FIR in respect of a cognizable offense that has taken place. And the reason was, as we discussed, is because once a court is seized with a matter, the court will know when it is best to pursue a case of fabrication of evidence. Now, this is one aspect of it, which is that only that court can make a complaint. But how does a court make such a complaint? And can an individual ask the court to make such a complaint? Or does the court do it on its own? That takes us to the next set of sections which are relevant. It might be a little technical, so I don't expect any of you all to know, but if anyone does, feel free to point it out. The section is 340 of the Criminal Procedure Code. 340 of the Criminal Procedure Code reads as follows. Procedure in cases mentioned in section 195. So you notice that section 340 refers to 195, which we discussed earlier, and it reads as follows. 341. When upon an application made to it in this behalf or otherwise, any court is of opinion that it is expedient in the interests of justice that an inquiry should be made into any offense referred to in clause B of subsection 1 of 185, which appears to have been committed in or in relation to a proceeding in that court, or as the case may be, in respect of a document produced or given in evidence in a proceeding in that court. So once again, the court has complete discretion when to decide that in the interests of justice, there should be an inquiry. Has false evidence been given before me? Has a fabricated document been produced before me? This can be done by the court on its own or on the basis of an application made before it. So for example, if I am a party in a trial and I think the other side is giving false evidence, I am not remediless. I can make an application before the court saying, look, he's giving false evidence or she's giving false evidence. But I can't decide that an FIR should be registered or a criminal complaint should be registered based. The court will consider my application and based on an inquiry conducted by it, decide whether to pursue a criminal case or whether to dismiss the application. The reason was given earlier, which is that since the court is seized with the matter, the court will know best whether this is the correct stage or not. After such preliminary inquiry that the court has conducted, as it thinks necessary, the court will A, record a finding to that effect that such an offense has been committed, B, make a complaint thereof in writing, C, send it to a magistrate of the first class having jurisdiction, and D, if the offense is bailable or non-bailable, it can even take steps towards taking surety or taking the accused into custody. Subsection 2 of 340, I won't read this, it's fairly straightforward. Subsection 3 is concerned with who can file this complaint. So for example, where the court making the complaint is the High Court, it is going to be an officer that the High Court may appoint. And in any other court, it will be concerned with the presiding officer of that. So are you understanding the scope? The penal provisions are contained in Chapter 11 of the Indian Penal Code. If you want to file a complaint for fabrication of evidence, you can't approach the police. because section 195 of the Criminal Procedure Code bars an individual from directly filing a complaint and bars a court from taking cognizance of any complaint unless it is filed by the court or an officer authorized by the court where the fabrication of evidence took place. This takes us to section 340, where either the court itself decides that I want to conduct an inquiry into whether perjury has taken place or fabrication of evidence has taken place, or a party makes an application to the court saying, please consider the fabrication of evidence that is taking place. And then the court decides based on that application on whether it wants to pursue the matter or not. And thereafter, the court can make the relevant complaint for fabrication of evidence. Section 341 deals with an appeal. So let's say, for instance, we're in a proceeding and I decide to file an application before the court saying the other party has filed fabricated evidence. And the court says, I disagree with you. I don't want to get into this question. Then under section 341, you can also file an appeal against the decision of the court saying, look, there was false evidence given. The court is refusing to pursue it. You please overrule that decision and ask the court to pursue it. Now, section 344 is the next section, which I think is extremely interesting, which is the procedure. Now, there are two situations where you can come up with false evidence or come across false evidence. One is during the trial, where you think one witness is lying or you think one document is fabricated. But the nature of a trial is that all questions are open. The court has not decided at this point whether the witness is telling the truth or not. The court has not decided at this point whether the document is genuine or not. In fact, in 60% of trials, 70% of trials, in civil trials, for example, many people dispute the validity of document. They say, I never signed this document, but this document is bogus. But if you file an application for false evidence at that stage, the court will usually reply with, I don't know if it's bogus or not at this stage. In fact, that is the crux of this entire trial, and that is where we're going through this trial. So this is not the correct stage to file this application. But at the end of the trial, when the court is passing judgment, the court is naturally going to have to come to a conclusion on whether one party forged a document or not. So the question then becomes, at the end of a trial, can a court then, at the time of judgment, decide, okay, it is clear that the plaintiff was trying to claim rights over this property based on a completely forged, leave and license agreement or a completely forged sale deed. At that point, after the trial is almost at its fag end, practically over, can the court initiate proceedings under section 304 through section 304? The answer is yes. The court can absolutely at that stage file a complaint in respect of forgery and fabrication at the time of judgment. But what about some cases where witnesses have told small lies, where witnesses have, a witness has come to court and said, I saw the accused over there, but it's been proved in the course of trial that neither witness was there nor was the accused over there. And the witness was a planted witness either by the police, because that is the reality of proceedings, or it is planted by the complainant, or it is a completely interested witness who lied to the police as well. So even the police have been misled. In such a situation, knowing that proceedings in courts in India are extremely cumbersome, and if you file a complaint under 340, it will take years to fructify. Section 344 of the CRPC allows for a summary procedure. I'm going to read section 344. If at the time of delivery of any judgment or final order, disposing of any judicial proceeding, which is what I was talking about, this is when the decision has come and the court has decided what's true and what's not. A court of session or magistrate of the first class expresses an opinion to the effect that any witness appearing in such proceeding had knowingly or willfully given false evidence or had fabricated false evidence with the intention that such evidence should be used in such proceeding, or if satisfied that it is necessary and expedient in the interest of justice that the witness should be tried summarily for giving or fabricating, as the case may be, false evidence, take cognizance of the offence and may, after giving the offender a reasonable opportunity or showing cause why he should not be punished for such offence, try such offender summarily and sentence him to imprisonment for a term which may extend to 3 months or to fine. Here's the thing. This is where a witness is simply given a fabricated false evidence and the court doesn't want to go through the elaborate procedure of filing a complaint because it has already somewhat come to a finding that this man or woman has likely done something wrong. It issues him a show cause, can follow a summary procedure and give him a small sentence of 3 months. Why I say small sentence is because if you would look at the other sections under the Indian Penal Code, they allow for much larger punishment. But 3 months allows you to follow a summary procedure and still sentence someone. The important part of this section, however, is the third subsection. Nothing in this section shall affect the power of the court to make a complaint under section 340 for such offence, which means that the court doesn't have to follow this summary procedure. If it thinks that the lie told by the witness is grave enough For example, in a trial concerned with capital offenses, or in a trial concerned with life imprisonment, it can go back to section 340 and file a criminal complaint and pursue proceedings. So you're understanding the scheme. Section 340 can be invoked at any point during a proceeding, including the end, wherein at any point the court can say, I think false evidence has been given. Section 344 deals with a limited situation where at the end of the trial, you want to quickly hold those individuals accountable who you think have lied. And therefore, you hold a summary proceeding and you can at most punish them with 3 months of imprisonment. This takes me to one of the last legal aspects that I'm going to deal with today, which is essentially that, do you think a strategy can be invoked with respect to false evidence? And I'll substantiate on that a little bit. Now I've told you that you can't file an FIR for false evidence. Now I've told you that you have to file an application before the court, and then the court has to conduct an inquiry, and then the court has to decide. And we all know these are slow procedures. So do you think it's possible that someone forges a document, gets that document involved in a legal case, and then tomorrow if I want to file an FIR about that document, the court will say, you can't file an FIR, this document is part of a case, you file an application before that court. Let's make this example a little more specific to make it clearer. I create a bogus transaction, a bogus sale deed, which I even get registered, where I execute a forged document on behalf of X and say X has sold the property to Y. And thereafter, I file a recovery suit. I get Y to file a recovery suit for money from X. Now, X wants to file an FIR saying that this is a forged document and Y should be held accountable. But Y, when X goes to file the FIR, Y will say, look, you can't register this FIR because this is pending before a court of recovery. So X can't file an FIR. X has to file an application under section 340 for false evidence before the concerned court where the recovery suit is taking place. Why this is crucial is an FIR for forging a sale deed would be registered under sections of forgery like 467, 468, 471, which are non-bailable sections, which can lead to arrest, which can lead to a speedier trial. Whereas a civil recovery suit in India will go on for 20, 25 years. So this will be a tactic that people will start using, where they'll forge a document, they'll file a civil suit on the basis of that document or involve that document in a civil suit, and thereby protect themselves from the other provisions of the criminal law, which are much more serious in nature and which will move much faster than both the civil suit as well as the section 340 provision. So the question becomes, does that make 195 a problematic provision? Does it protect accused individuals, or can accused individuals misuse it to protect themselves? What ended up happening is this issue came up before the Supreme Court in several cases. And finally, in Iqbal Singh Marwa versus Meenakshi Marwa, the Supreme Court settled the issue, saying that, yes, if a document is forged in the course of proceedings and in relation to those proceedings, then the bar under section 195 applies. Then you cannot straight away file an FIR about it. But if a document is forged before and thereafter simply used in court proceedings, then the bar of section 195 does not apply. Then there is no restriction on an individual approaching the police and filing an FIR, even if that document is involved in court. Here's the thing. I've told you, I think, and Nagesh as well, section 195 bars one from filing an FIR in cases of forgery, right? When the forgery is concerned with court proceedings. When the forgery is concerned with fabrication of documents involved in court proceedings. Now, what this could potentially lead to is a tactic where an accused forges a document and to avoid an FIR against him, gets that document involved in court proceedings. So when someone goes to the police and tries to file a proceeding about that forged document, X will simply say, you can't take an FIR, you can't prosecute me because you have to approach that civil court and file an application under 340 over there. I'll make this a little more detailed with a little different example from earlier. Let's say I want to falsely claim the right to Vithal's property. Vithal has a house. I want to claim that house. I will forge a sale deed where I will say Vithal has sold me this house for, let's say, 10,000 rupees. The house is probably worth 3-4 lakhs. I will forge Vithal's signature. I will sign the document on my behalf. And therefore, now suddenly there is a completely forged document that exists wherein Vithal has sold me the house for 10,000 rupees. And I will even give Vithal 10,000 rupees. I will bank transfer Vithal 10,000 rupees. Vithal will wonder why he got this 10,000 rupees, but he won't think too much about it. Thereafter, 1 month later, I will file a suit for specific performance and for eviction of Vittal, saying that Vittal is living in my house, he has sold me the property. This is the sale deed. Vittal has to leave the property and give me the house. I've given him 10,000 rupees. Now, Vittal doesn't find out about this bogus document until subsequently when he gets notice of the suit. And Vittal immediately realizes he's never signed this document. How can this sort of case exist? What is this bogus? And I have clearly committed a huge criminal illegal act wherein I have forged a document of sale, which is punishable under Section 467 with life imprisonment, Section 468, 471 with 7 years imprisonment. So, what is Vittal's natural thought? Vittal's natural thought is, I need to file an FIR for this forgery. But there the bar under Section 195 comes in, where it explicitly states that no court can take cognizance of a complaint in relation to a document involved in a court proceeding being fabricated or forged, unless that court files a complaint. So when Vittal goes to file an FIR, the defense I will use throughout is that Vittal cannot go to the police. Vittal has to file an application before that court, where I've already filed a recovery case, a suit for specific performance, and a suit for eviction. And that court will respond to a so Vittal goes, he files an application before that court saying, please prosecute him. This is a forged document. And like we discussed, what will the court will say? I don't know if that's a forged document right now or not. I will only find out if that's a forged document at the end of the trial. The trial will take 20 years. And suddenly Vittal is stuck because I have forged a document. I've committed a serious offense punishable with 7 years with life imprisonment. But there is no criminal case against me because the court is saying it is a civil suit. It will take 15, 20 years to be decided. And Vittal has no option but to then spend 20 years dealing with the civil suit, and I get away scot-free for my criminal acts. And eventually my plan will be to get Vittal to settle because he'll get frustrated. Now, the Supreme Court dealt with this issue in the judgment and said, if forgery has taken place prior to a suit being filed, or when the documents were not connected to the suit, like in this case, where I first forged the document, and then based on the forged document, I filed the suit, then the bar under Section 195 does not apply. Then Vittal can go to the police and file an FIR. And even though the matter is pending before court, Vittal will say, look, this forgery is not once the document was in the possession of the court. This forgery was not in connection with the proceedings while they were going on. This forgery was prior in time to the suit being instituted. It is a separate offense from the suit and has to be investigated by the police, and the police can register this. And one of the reasonings, or one of the explanations given by the Supreme Court was exactly the example, which is people can then forge documents and file civil suits that they know take time and therefore arm twist other individuals because they will be safe from criminal proceeding. And that's why the bar of Section 195 cannot be allowed to extend when the offense. But I hope that's clear this time. All right, that takes me to the last part of this lecture, which is the practical realities of fabrication of evidence in India. Now, there are two ways in which I want to approach this. One is there is a lot of literature, and by literature, I mean, academic studies, scholarly articles on the inherent nature of courts in India not being taken very seriously in terms of perjury. People are unfortunately willing to take a risk and lie in court, give false in court, give forged documents in court very freely in our country. And the reason for this reason for this confidence and this lax attitude is because the provisions of perjury and giving false evidence are very underutilized. Because our courts are so overburdened, because they are so slow, because they have such a huge backlog, they cannot devote their time and energy to filing complaints under 340. They cannot take these complaints seriously because they have serious offenses that are already not pursuing, trials are not moving in. So how can you worry about smaller offenses like 340, like proceedings under 340? And because witnesses know and parties know that applications under 340 are not taken very seriously, are not pursued aggressively, they might as well take a risk and lie and quote unquote baki dekha jaye. I can tell you in my own experience, I have filed an application under Section 340 in the High Court 3 years ago, and it hasn't moved. The case only hasn't listed. And that was for a lie in the High Court. I have seen magistrates direct the registration of a complaint under the procedure of 340, and it's taken months and months of following up with the registrar of that magistrate court before finally a complaint was registered. And still that complaint has not moved. So the problem in India is twofold. One is perhaps the problem with people, which is that we aren't afraid of lying. And we are okay with lying if it serves our own interest. And I'm not blaming any particular community. I'm not blaming it's not like the police lie and people don't. People lie in civil proceedings. People lie in criminal proceedings. The accused definitely lies. Even the state has on instance been caught brought up witnesses who were never at the scene of the crime. So perhaps the problem starts with the willingness of individuals to lie for their personal benefit. But the institutional failure is that courts do not have the bandwidth and perhaps to some extent the inclination to take such lying seriously. And therefore, it is rampant. And it might take some time before you come across a case where Section 340 proceedings have been taken seriously, where parties have backtracked, where it's not simply a pressure tactic in the course of a long litigation. So I'll leave you with that thought, which is we studied all these provisions and these mechanisms, but in my experience, courts aren't very serious about it. And parties only use it as a pressure tactic to pressure other witnesses and to pressure the other party into getting into some set. And I think that it is a failure of our system, perhaps not attributable to anyone in particular, because of the sheer infrastructure shortage that exists in courts in India in terms of number of judges and the bandwidth that judges have, that people can lie in court, and even when they're caught lying, even when an accused is acquitted and it's proved and the court has believed that certain witnesses have lied, courts simply won't adopt proceedings under Section 340 or 344 because they just have too many other things to do. And this leads to witnesses continuing to lie. Thank you. That's all on this subject. If you have any questions, if you have anything you want to discuss, you feel free to ask right now.
So the first question is, can you shed some light on fabricating electronic evidence?
So I'll tell you something interesting that happened to me in a trial the other day. And I'll give you some theoretical background because I'm not sure of, if everyone would be aware of that. So any electronic evidence that you give has to be accompanied by a 65B certificate. A 65B certificate under the Indian Evidence Act broadly states that, yes, I have taken a proper printout. Yes, I have not tampered with the device. Yes, I am regularly accessing the device. I know how the device functions. Nobody has tampered with it. And yes, the printout reflects the original, which is the electronic material. So what happened to me in this trial is my client had given me an email, and he had also very happily, like I said, Indians are relaxed about these kind of things. We as a community don't take too much stress in court. He had signed a 65B certificate, signing on the document and saying that, yes, this is a printout of an email. Yes, this is my email ID. Yes, this is my computer. I have not tampered this, that. I tendered it in court. And the other side took an objection saying, this doesn't look like the printout of an email. When you print out an email, the header of Gmail always comes. But there's nothing. This is just text. Some part of the email is completely detailed. Some part of the email is, the email ID was not written, only the names were written. And now the court looked at me at this stage and said, you've signed a 65B certificate. So you've complied with the legal requirement, but I don't know if this is reliable. And the only way in which you can challenge fabricated evidence, electronic evidence, is by questioning the person who's producing it. So you have to question whether the printout is authentic. You have to question whether they're in control of the device through which it came. And you have to question whether they have tampered with it. And it becomes like any other evidence. If I say something in court in the nature of, yes, I was there at the scene, and yes, I saw the accused. How do you break me as a witness? You ask me, why were you there? And I might have an explanation for that. And then you ask me, what time were you there till? And I might have an explanation for that. But if you tell me who else was there at the scene, if I hadn't thought about that question, I might fail to come up with a good answer. And if I don't come up with a good answer, you realize I'm lying. So what you can do in electronic evidence, for example, is this your laptop? Yes. Are you regularly accessing? Yes. When did you take this printout? I took it at 2 p.m. Through which printer? Through this printer. What else is in that folder on the computer? And the person may stutter. And you ask surrounding questions to show that he is lying. Since when have you had this laptop? If the person didn't think about it, he may not be able to answer. And then you suddenly know that that's probably not his laptop, that he might not. These are the tactics that you use for cross-examination smoothly blend into what you have to do in this kind of case as well.
Okay.
I hope that answers
The next question is, what steps can one take to ensure that the investigation officer does not fabricate the evidence?
So there's there's absolutely nothing that you can do on a broader level which is not fact specific. You have to trust the investigating officer, and when he's fabricating it, you have to catch him in cross-examination. But there are some things you have to do. For example, let's say the crime has taken place in a building, and that the crime did not actually take place, and they've just fabricated, they're making a false case that you were at the scene of crime. You file an application under Section 91 before the court saying, you please call for the CCTV footage from that building and you keep it safely with you. I will use it at the time of trial because right now, as an accused, I don't have a right to the evidence. But if I don't file this application by the time the trial starts 4 years later, the building will have gotten rid of its CCTV footage. So that's one tactic that we use. The other is you call for the CDR. CDR are call data records. You file an application saying, call for my call data records, they'll prove I was somewhere else. So in these ways, you have to preserve the evidence that's in your favor, but there's no hard and fast rule. And the only thing I can say to this is when the police or anybody fabricates evidence in the course of an investigation or whatever, nobody is so won't leave telltale signs. And you'll see those telltale signs. You'll see that sometimes witnesses in a panchnama are repeat witnesses. Or you'll see that if you ask the witness 4 questions, during cross-examination, you'll realize he was never really there. That's how you usually.
Okay. The next question in the registration form was, can there be a test that the Indian courts can establish in order to ensure admissibility of genuine evidence?
I think there is a test. See, you have to understand that the Indian Evidence Act differentiates between admissibility and reliability. And I think that that's quite a beautiful distinction because then the question of admissibility is whether the evidence should come on record and reliability is whether you can trust it. So genuine evidence will easily be admissible just by virtue of being relevant and having provisions to allow it in. And then a court, which we assume is a trained judge, an experienced judge who knows what's what, will be able to decide whether to rely on it or not. In my experience, at least, genuine evidence makes the cut usually. It's the not so genuine evidence that people struggle to bring it in. Once they bring it in, that problem. All right, what is the status of WhatsApp messages as evidence? So they are admissible. They have to be proved in a certain way, but you can't, you ideally will have to prove one, that the WhatsApp message exists, two, that the number from whom it came belongs to the person you claim to be talking to. That person can always take a defense saying someone took my mobile and sent it. And that's a question of, building a case. But WhatsApp messages are admissible like any other form of electronic evidence. What if a false cross case is filed to trouble victim? That happens all the time, and especially say in areas like marital litigation, things like that. Parties often file cases against each other, but that doesn't mean that the law doesn't protect you, and you'll easily use discharge and quashing and other options to protect yourself. Currently, the call recording of threatening on call are acceptable or not. Of course, all call recordings are admissible as evidence, as long as you can prove them within the confines of the law. If you record a call and someone threatens you, that is admissible in evidence. Any landmark case on admissibility of evidence, there are several. You can look up any commentary. I can't, that's too broad a question. You shouldn't, I would suggest you don't start from one case. You read through a commentary and then you move on to specific cases cited in the comment. The last question is, nowadays for call recording, it has to be prior consent from the other party. To my knowledge, this issue hasn't been decided. In family law context, perhaps there have been some judgments which talk about how illicit recordings cannot be used or should not be used. But there's no provision which discards call recordings that were done without consent. And I don't think such a provision can exist because in some situations you will have to introduce recordings which were necessarily without. It's, the context matters with respect to what you're saying, Avinash. And I think there are some situations where call recordings, even without consent, can be.
Thank you so much, Aditya, for such a vibrant and such an illuminating webinar. Thank you.
All right. Thank you very much.